Mr. Speaker.
I call the honourable member Andrew Little.
Thank you, Mr. Speaker. Honoured to take a call on this very important report, and I'd like to acknowledge the work of both the Attorney General and the committee itself for producing, I think, a very good discussion of the background to it and bringing perhaps to a head years of concern about lack of clarity and understanding about the nature of both parliamentary privilege and parliamentary proceedings. Mr. Speaker, this, as the Right Honourable Winston Peters said, is not just a constitutional issue, it's one of the most important constitutional issues. And I might say, in the context of what is meant to be apparently a time of national debate about a constitution and whether we should have a written one or not, this at least is a matter of real constitutionality. It is about how power is distributed and how it is represented, and it is about the relationship between the different branches of government. And these are questions that go to the core of what makes up a constitution, and it is good that we are having an open discussion, at least in this House this afternoon, on this important issue. Mr. Speaker, as has been clear from the previous speakers, the heart of this debate is about what constitutes the proceedings of Parliament. And the case that went to the Supreme Court that has led to the Privileges Committee considering the matter and writing this report was a defamation case. And the Defamation Act itself, and a piece of legislation with which I've recently become familiar, along with a colleague of mine, uses the term privilege. There's not a great deal in common with the Lee case, because in that case, of course, there was a minister being advised, and it was the minister's advisor who was really in the gun, because of what he said or is alleged to have said in advising the minister. In the more recent case involving Mallard and Little, it was a minister who took umbrage at comments made, the veracity of which have never been tested, and indeed the case has been pulled and we'll never know what the result will be. But, Mr. Speaker, the Defamation Act itself uses the term privilege in terms of absolute privilege, qualified privilege and parliamentary privilege, notwithstanding that those terms have different meanings in each case, or at least qualified privilege and absolute privilege on one hand and parliamentary privilege on the other. As the Attorney General said, parliamentary privilege is about protection, protecting members of this House who, having been elected to come here, must be allowed to do so, to fulfil their obligations and duties without fear of being harassed and harangued by the powerful and the mighty and the wealthy as they do so. And so, sir, it's accepted that MPs must be able to prosecute their role. We must be able to fulfil our duties and obligations without fear from others in the community who would seek to prevent us from doing so. Sir, it's also important that there are safeguards for citizens because, as the Attorney General correctly pointed out, parliamentary privilege is about protecting members, but it is not about elevating members to an unnatural status within the community so that they are beyond reach or cannot be touched if they transcend or transgress either the law or other accepted rules and principles. And so there must be safeguards for citizens as well. And although I am new to this House, and I haven't been here during the development of the existing standing orders, there are standing orders that do go to the extent of protecting citizens, and so that if a citizen who would not otherwise have a voice here is referred to, particularly if they are referred to in disparaging terms, there is a process by which they can have their reputation protected, or at least have a version represented. And likewise, when it comes to the relationship between this House and the other branches of government, principally the judiciary, there are standing orders that seek to preserve and protect the relationship between them. Sir, sitting behind this report and the recommendation of it, which is to provide statutory clarification of parliamentary privilege, we have the case of the Attorney General and Lee case, which focused on the necessity principle, what is needed to make the absolute privilege of Parliament functional and workable. That was the focus of the Supreme Court, as opposed to what I think, with great respect, was really at the heart of that case, which was more about what inquiry was needed to ensure that the Minister could fulfil, in that case, his obligation to answer fully and properly to the House, and what was needed to protect the citizen. And so a minister must be free in taking advice, to pose questions and obtain advice, both orally and written, from officials on whom they are dependent and reliant to get advice. And that must be able to be conducted in a free and frank way, as the expression is given and indeed reflected in the Official Information Act. The free and frank expression of officials must be preserved and protected to enable the role or the function of government to be carried out. And so, sir, it appears in my humble view and respectful opinion that the Supreme Court conflated the test of needed to protect the citizen's right, in this case Ms Lee, with the manner in which Parliament must conduct its business. And so, sir, I think that the committee has correctly struck the balance and concluded that it is right for this House to enable it to conduct itself properly and its members to conduct themselves without fear of harassment from others in the community, to legislate for a definition of parliamentary privilege and parliamentary proceedings. That need not cut across citizens' rights and the ability for citizens to stand up and preserve and protect their reputation. That can be accommodated in the standing orders of the House, as in my view it already is. But we do need to be aware, at least in the public debate that will happen about this legislation, that there will be a tension between citizens and their representatives in this House as we seek to protect our ability to do our job. It's interesting that the Bill of Rights, the 1688 Bill of Rights, the origin of that statute was, the focus was more about the relationship between the Crown or the monarch and Parliament. And that was a Bill of Rights that was about preserving and protecting the role of Parliament as against the monarch of the day, and ensuring that the Crown could not unduly interfere in the conduct of Parliament as it went about raising taxes and passing laws, and that it could not be gainsaid by the monarch of the day making their own dictates and passing their own laws unilaterally without the proper involvement and consent of Parliament, and likewise levying taxes. That's what the 1688 Bill of Rights was about, and that's what it was referring to when it talked about the proceedings of Parliament in Article 9, when it sought to preserve and protect those. And it is clear from a reading of that 1688 document that the reference to the proceedings of Parliament were intended to be broad, were intended to give effect to Parliament in all its dimensions, conducting itself and fulfilling its business. And so, sir, Mr Speaker, I want to once again acknowledge and record, I think, a very good piece of work in the document that has been produced and which we're discussing now, and I look forward to the legislation as it is drafted and as it comes before this House for more considered and detailed debate.
Members, this debate has concluded. The question is that the motion be agreed to. Those of that opinion will say aye. Aye. To the contrary, no. The ayes have it. The House now comes to consideration of an interim report of the